Legislative Brief of the Bharatiya Vayuyan Vidheyak 2024. The bill was introduced by the Minister of Civil Aviation on in the Lok Sabha on July 31, 2024. The bill was passed by the Lok Sabha on August 9, 2024 and is pending before Rajya Sabha. The bill seeks to replace the Aircraft Act 1934. It retains most of the provisions of the Act. The Act sets up DGCA for overseeing safety and performing regulatory functions. The Act sets up BCAS for overseeing security and AAIB for investigating accidents. So तीन चीजें सेटअप करता है ये एक्ट, DGCA, BICAS and AAIB. The central government will exercise superintendence over these bodies and it may review or modify their orders. The bill retains these provisions. The Act regulates activities related to aircrafts, including manufacturing, possession, use, and trade. The bill retains these provisions and also provides for regulation of aircraft design. Offences include flying on aircraft dangerously, carrying arms or explosives in an aircraft, and depositing rubbish or slaughtering animals near airports. These are punishable with imprisonment up to 3 years, a fine up to 1 crore, or both. The bill introduces a provision for second appeal against decisions related to the imposition of penalties for violating rules under it. Key issues. The civil aviation sector was open to private airline operators in 1994. In other sectors such as telecom, electricity, and insurance, private sector participation was allowed since 1991. These sectors have an independent regulator. Unlike them, DGCA is not independent but of government control. Unlike them, DGCA is not independent of government control. The bill empowers the government to appoint an arbitrator for determining compensation in certain cases. Supreme Court has held that power to unilaterally appoint an arbitrator for one party is violative of right of equality under Article 14 of the Constitution. The bill gives discretion to central government to specify criminal penalties for violation of certain rules. This may go against the principle of separation of powers. The following key laws govern the civil aviation sector in India: the Aircraft Act 1934, Airports Economic Regulatory Authority of India Act 2008. The 1934 Act regulates various activities related to civil aviation and licensing of airports. The 2000 Act set up an independent authority to regulate tariffs for aeronautical services delivered at airports and monitor performance standards of airports. The 1934 Act was amended in 2020 to grant statutory recognition to DGCA, which performs regulatory functions and oversees safety, Bureau of Civil Aviation Security, which oversees security, and AAIB, which investigates aircraft accidents. In 2023, correction, in August 2013, the Civil Aviation Authority of India Bill 2013 was introduced to set up an independent regulator for safety. However, the bill lapsed with the dissolution of 15th Lok Sabha. The Bharatiya Vayuyan Vidheyak 2024 was introduced in Lok Sabha on July 31, 2024 and passed by Lok Sabha on August 9, 2024. It seeks to replace the 1934 Act and it retains the regulatory structure under the Act. Key features. Authorities. The Act sets up three authorities: DGCA for performing regulatory functions and overseeing safety, BCAS for overseeing security, and AAIB for investigation of aircraft accidents. The central government exercises overall superintendence over these bodies. The government may issue directions to these bodies and review their orders. The bill retains these provisions. It adds that appeals against orders of DGCA or BCAs will lie before the central government. No further appeal is permitted. Regulation of design of aircraft. The Act regulates activities related to aircrafts including manufacturing, use and operation, operation and trade. The bill retains these provisions. It adds powers to regulate designs of aircraft. Power to make rules. The Act empowers central government to make rules on matters including regulation of specified activities related to aircraft and matters on licensing, certification and inspection, regulation of air transport services, implementation of Convention on International Civil Aviation 1944. The bill retains these provisions. It adds that central government may also make rules or radio telephone phone operator certificate and licenses under the International Telecommunication Convention. Offences and penalties. Bill specifies several offences and penalties. Following offences will be punishable with imprisonment up to 2 years, a fine up to 1 crore years, or both. Violating rules on carriage of certain prohibited goods in aircraft such as arms and explosives, flying aircraft in a manner to cause danger to a person or property, failure to comply with the directions of DGCA and BICAS, violation of rules prohibiting slaughter and deposit of rubbish near airports will be punishable with imprisonment up to 3 years, a fine up to 1 crore, or both. The bill gives discretion to the central government to specify civil or criminal penalties for violation of rules concerning regulation of activities to aircraft such as design, manufacturing, use, and trade, implementation of international convention, investigation of accidents, protection of public health, powers to detain aircraft. Civil penalty may be up to 1 crore rupees. Criminal penalty will be imprisonment up to 2 years and a fine up to 1 crore rupees or both. Adjudication of penalties. The Act allows the central government to impose penalties for contravention of rules. It empowers the central government to appoint an officer for adjudication of penalties. This officer must be of the rank of Deputy Secretary to the Government of India or above. Decisions of the adjudicating officer may be appealed before an appellate officer who must be of a higher rank than the adjudicating officer. The bill retains this and adds an additional level of appeal. The appeal against the decisions of the first appellate officer will lie before the second appellate officer, and second appellate officer must be an officer of a higher rank than the first appellate officer. Key issues. DGCA remains under direct government control. Section 4A, Clause 1, and the Act establishes Directorate General of Civil Aviation (DGCA) for performing regulatory functions and overseeing safety. DGCA will be headed by an officer appointed by the central government. The central government will exercise superintendence over DGCA. It may modify or cancel DGCA's orders, and its directions to DGCA will be binding. The bill retains these provisions. Similar to the Act, the bill does not specify the qualification of for the Director General, the manner for his selection, or the tenure of his service. That is, the DGCA is similar to government department and is not independent from the government for decision making. This regulatory structure is different from other sectors of the economy with significant private sector presence such as telecom, electricity and insurance. With reference to airlines, both passenger and cargo segments are fully serviced by private carriers. Similar to civil aviation sectors such as telecommunication, electricity, and insurance that were erstwhile government monopolies, have also been opened up to private participation after 1991. These changes have been accompanied by the establishment of an independent sectoral regulator created by law. These regulators determine necessary conditions for obtaining licenses, guidelines for pricing of services, method of recourse to the consumer, a fair system of private operators, and to ensure independence, technical qualification, terms, tenure of service of members of these bodies are defined by law. Appeals against the decision of the regulators lie with the appellate tribunal. OECD observed that independent regulators are set up to prevent market failures due to bureaucratic influence, lack of technical expertise, conflicting interest between government and non-government entities. It noted that security of tenure allows them to shield the sector from fluctuations in political and economic business cycles. In the civil aviation industry, tariffs for aeronautical services and performance standards at major airports are regulated by an independent Regulator, Airport Economic Regulatory Authority of India. Appeals against the order of ERA are heard by an independent tribunal, the Telecom Dispute Settlement Appellate Tribunal. ERA was set up under an act passed in 2008. Second is arbitration for determining compensation amount. The act empowers the government to issue directions for demolition of or modification of buildings, structures, or trees within specified distance from an airport. The affected owners are eligible to receive compensation will be determined by mutual agreement. If an agreement is not reached, the government may appoint an arbitrator. The arbitrator must be a person who is or is qualified to be a High Court judge. The bill retains these provisions. We discuss issues with these provisions below. Power for government to unilaterally appoint arbitrator may violate right to equality. The Supreme Court held that unilateral appointment for arbitration by one party is violative of the right to equality under Article 14 of the Constitution. It observed that a clause allowing one party to unilaterally appoint a sole arbitrator may raise doubts about the independence and impartiality of the arbitrator. It notes that it amounts to appointing judge to one's own cause. Under the Arbitration and Conciliation Act 1996, arbitrator is appointed as mutually agreed by the parties. The bill specifically states that Arbitration and Conciliation Act 1996 will not apply to arbitrations under the bill. Next is the bill exempts application of Arbitration and Conciliation Act 1996, which is different from other laws. The Railways Act 1989, National Highways Act 1956 provides for similar compensation determination process. They also empower the central government to appoint arbitrator in case of disagreement of compensation amount. However, they state that 1996 will apply to every arbitration under the Act. In case of Metro Railways, the Metro Railways Construction of Workers Act 1978 originally provided for appointment of an arbitrator in case of disagreement or on the compensation amount. It was subsequently amended in 1982 to replace the arbitration process with an appeal to an appellate authority. Under all three acts, compensation is determined by an authority appointed by the government instead of mutual agreement as under the bill. Criminal penalties through rules may go against separation of powers. The bill provides for breaching rules notified under certain provisions may be penalized by central government through criminal penalties. The punishment will be imprisonment up to 2 years with fine up to 1 crore or both. These rules pertain to a wide range of activities including regulation of activities related to aircraft such as design, manufacturing, use and trade, implementation of international convention, investigation of accidents, protection of public health, powers to detain aircraft. Thus, the bill gives discretion to the central government on deciding which violations constitute criminal offence and which will attract criminal penalties. Delegating these powers to executive may violate the principle of separation of powers. This raises question whether legislative should decide criminal offences and penalties for them instead of delegating them to the government. For violation of certain rules, penalties have been specified in the bill itself. These include violating rules on carrying arms, explosives, or other dangerous goods in the aircraft, depositing rubbish within a radius of 10 km of airports. Under laws on railways and metro railways, all offences and penalties are listed in the Act. The Bharatiya Vayuyan Vidheyak 2024. The Bharatiya Vayuyan Vidheyak was introduced in Lok Sabha on July 31, 2024. The bill seeks to replace Aircraft Act 1934. The Act regulates the civil aviation sector. It sets up three statutory bodies: DGCA for performing regulatory functions and overseeing safety, BCAS for overseeing security, and Aircraft Investigation Bureau for investigation of aircraft accidents. The central government may issue directions to these authorities and also review their orders if necessary in public interest. The bill retains the regulatory structure and most of the provisions under the 1934 Act. Regulation of design of aircraft. The Act regulates various activities related to aircraft, including manufacturing, possession, use, operation, and trade. The bill retains this and also seeks to regulate the design of aircraft. Powers to make rules. The Act empowers the central government to make rules on several matters. These include regulation of specified activities related to aircraft and matters related to licensing, certification, and inspection, regulation of air transport services, implementation of convention related to international civil aviation of 1944. The bill retains these provisions and adds that central government may make rules on radio telephone operator certificate and licenses under International Telecommunication Convention. Appellate mechanism. The Act allows the central government to impose penalties for contravention of rules. It empowers central government to appoint an officer for adjudication of penalties. This officer must be of the rank of Deputy Secretary or to the Government of India or above. Decisions of the adjudicating officer may be appealed before an appellate officer who must be of a higher rank than the adjudicating officer. The bill retains this and adds an additional level of appeal. The bill against appeal against the decisions of the first appellate officer will lie before the second appellate officer. The second appellate officer must be an officer of a higher rank than the first appellate officer. Appeals against orders of DGC and BCAS. The bill adds that appeals against an order of DGC or BCAS will lie before the central government. No further appeals will be allowed against the central government orders. So, this was the summary of this bill. Thank you so much for listening. See you in the next one.